Good afternoon and welcome to the California Apartment Association's New Laws webinar. My name is Mike Nemeth, Director of Communications at CAA, and I'll be your moderator. We have a number of industry experts with us today for today's webinar, including Dana David, CAA Vice President and Legislative Chairwoman. Dana is also President at E&S Ring Management. Also with us today are Deborah Carlton, CAA's Senior Vice President of Public Affairs, Sean Apekian, Vice President of Public Affairs, and Heidi Palutke, Vice President for Compliance and Education. At this point, I would like to point out the dialog box, which should be at the upper right portion of your screen. As questions occur to you during the webinar, this is where you'll want to submit your questions. Please keep your questions brief. We'll answer as many as possible during a question and answer period at the tail end of this webinar and answer the rest online. Later today, we'll email you a link to a members-only webpage on the CAA website that you'll want to bookmark. It will include a video player to rewatch this webinar, the PowerPoint slides you're about to see, links to important background papers, and by Monday afternoon, it will include a frequently asked questions page that attempts to answer all the questions that you submit this afternoon. With that, I'll turn it over to Dana David.
Good afternoon, everyone. My name is Dana David, and as Mike indicated, I am the president of E&S Ring and was honored to serve as the chair for this year's CAA Legislative Committee. I'm very impressed with the number of attendees today. Thank you for all being here. Our presentation should last about an hour. We're going to tell you about the legislative year, which will include the priority bills that failed passage and the new laws that will take effect in January. We're also going to tell you about the California statewide November elections and cover some local measures around the state, primarily the rent control measures in Northern California. We will conclude by providing you with the information you'll need to operate next year in compliance with the new laws. I want to start by thanking the members who volunteered to help CAA take positions on the bills that were introduced this session. We had a large group of members who helped. Our legislative subcommittees are made up of rental property owners, management company personnel, attorneys, and industry vendors who help CAA decide positions on legislation. This year we had over 90 people who participated. We have 4 dedicated lobbyists who take care of us at the state capitol, and we have local government staff in every major area of California. We also have compliance staff and attorneys who help ensure that we have forms and information we need to operate. I also want to thank the CAA staff, namely Sean, Deborah, Robert, and Heidi, and all the other CAA staff that help read all the bills and help us this year. Specifically at the Capitol, a total of 5,020 bills were introduced this year. Each bill was amended on average of 6.2 times, which means that our staff reviewed over 32,240 bills. CAA staff, along with our committee members, identified 277 bills with the potential to affect our industry. CAA took formal position on 148 bills. 69 of those bills went to the governor for consideration. He signed 61 of those bills and vetoed 8. With that introduction, I'm going to turn it over to Deborah Carlton, our Senior Vice President of Public Affairs, and the team to highlight for you the priority bills that were introduced and those bills that became law, which many have impacted on some of your businesses.
Thank you very much, Dana. My name is Deborah Carlton. I am your Senior Vice President of Public Affairs. This afternoon, I, as well as Sean Apekian and Heidi Palutke, will share with you the bills that failed passage, and we do that because many of these bills return on an annual basis and we see them again. So we'd like to share this with you so you know what we dealt with each year. So I'm going to ask Sean to first tell you about the first bill that we dealt with this year.
Thank you, Deborah. The first bill, and probably one of the most controversial for the rental housing industry, was Senate Bill 1053 by Senator Leno from San Francisco. This bill had to do with the Section 8 mandate. And what the bill attempted to do was redefine the source of income discrimination to include Section 8 vouchers, thereby prohibiting rental property owners from refusing to accept tenants simply because they had Section 8 vouchers. Basically, what that means is that the Section 8 program would have been mandatory, and you would not have been able to deny a tenant because of Section 8. This was quite controversial, but we were successful in stopping this bill early on in the Senate from moving forward because a number of other legislators realized that this would be a very problematic piece of legislation.
Thank you, Sean. The second bill that you see on your screen is a bill that was introduced by Assemblymember Calderon, AB 2282. It started out as a registration requirement for homeowners who had single-family rentals. As it was introduced, CA opposed the bill. It would have required single-family rental homeowners to register their units with the state of California. The bill was later amended to require only publicly traded companies, real estate investment trusts, that owned more than 100 single-family homes to register. Now, this bill came about because after the foreclosure crisis, many publicly held companies purchased thousands of single-family homes and converted them to rental properties. They did that, obviously, because many of these homes were sitting vacant, and they purchased them directly from the banks. Assemblymember Calderon thought that there may have been some problems as a result of some of these companies holding so much interest in single-family homes. I will tell you, however, he was not successful moving this legislation, and of course we were concerned about the precedent that it would have set, requiring homeowners to register their properties with the state of California. The second bill, also by Assemblymember Calderon, attempted to get at the same issue, AB 2283, would have impacted the public retirement systems, our Teachers Retirement Board and Public Employees Retirement Systems, who had invested in publicly traded companies that had held these large amounts of single-family homes and were using them as rentals. Again, Mr. Calderon was not successful with this legislation, and there was a lot of opposition, not only from the retirement boards, but also from the California Apartment Association and the real estate trust organizations in general.
The next bill has to do with the State Ellis Act, Senate Bill 364, again by Senator Leno. And what this bill would have done was prohibit rental property owners from removing rental units from the market or moving into their own units unless they had owned their property for 5 years. This is an issue we've seen for 3 years in a row now. Again, extremely controversial issue. This is a significant problem for rental property owners. If they don't have the ability to exit the rental market, forcing them to hold the property for 5 years can be very troublesome in certain circumstances. So we've defeated this bill 3 years in a row now. We anticipate some other sort of measure again in the future on the Ellis Act.
Thank you, Sean. The second bill, inclusionary zoning, AB 2502 by Mr. Mullen. This would have affected those individuals who build new rental housing units. It would have allowed local governments to mandate that a certain percentage of new developments be affordable to low-income individuals. It really was focusing on an appellate court decision in the case of Palmer versus the City of Los Angeles, where Mr. Palmer was successful against a lawsuit in the City of Los Angeles that challenged the ability for local governments to mandate basically rent-controlled units in new construction. That bill was not successful. We do know, however, of course, that many local governments already have various types of inclusionary ordinances, but they have to follow a mandate under state law. So this bill did not change those current mandates and did not change the Palmer decision in the City of Los Angeles. So those were the highlights. While we, of course, as Dana pointed out, there were many bills that we were able to stop this year that would not have helped the rental housing industry. We knew we didn't have enough time to cover all of them, and we'll make sure that we provide to you a list of all of those bills, and in fact, you can get those on our website already today. So those are just some of the highlights for you of the bills that were not successful in moving forward. We're going to now move into that segment of our seminar where we talk about the laws that now will go into effect in 2017. I'm going to ask Heidi to give you a summary of this one because this will affect everybody, and we have forms that will help you with this new law.
Well, hopefully bed bugs won't directly affect everyone, but everybody does need to start to include a disclosure regarding bed bugs in their lease. There's specific language that has to be included in the lease starting July 2017. And if you are not renewing a tenant's lease before that date, the notice has to be provided to all other existing tenants by 2018. That notice basically consists of two parts. One is basic information about bed bugs, how to identify them, and their specific language from the statute. And then the other part is your property's specific procedure for the tenant to report bed bugs to you so that they know who to call and so forth. There are a couple other parts to this legislation. Under existing law, tenants are protected against retaliation for things like reporting code violations. Reporting a suspected bedbug infestation to the landlord has been added to this section protecting tenants against retaliation. There's a prohibition against renting out a unit that you know to be infested by bed bugs. And there's also a requirement that when you do have the pest control operator come out to inspect for bed bugs, you have to provide the findings of that inspection to the affected tenants. We do have a new form, a bed bug addendum. It's similar to the one we had previously, but it includes the required language. And there's also an amendment in our rental agreement relating to bed bugs, but I'll talk about that a little bit more later.
And we will also have a more in-depth webinar on this topic
in February.
In February, exactly. So watch for information about that, and we'll put that in the general information that we're going to send out to you. I don't know that we have a very specific date yet, but we'll have experts who will participate with us during that webinar. I think that will be very helpful for all of you. So probably the top question we've been getting as a result of Proposition 64 that passed in November is the legalization of recreational marijuana. I will tell you, however, the initiative expressly allows owners of private property to prohibit any of the actions related to marijuana, such as growing marijuana, using marijuana, etc. Rental property owners can prohibit those actions at their rental properties. CAA's lease agreements specifically prohibit all of the actions related to marijuana, and that would otherwise, of course, be allowed under this initiative. In addition, the smoking prohibition within our lease has been expanded to include smoking of any substance, as well as the use of electronic cigarettes or vaping. We do have a background paper on this topic that we will also provide to you at the conclusion of this webinar. Now, this is a bill, or a topic, I should say, that we've been working on for nearly a decade or longer. Senate Bill 7 was signed by the governor. It's, of course, about water conservation and specifically a mandate for only new multifamily construction, which is defined as 2 units or more. They must include water submeters for each individual rental unit. So at the same time, however, if an owner has a building that was constructed before January 1st, 2018, and he or she elects to install submeters, or even if you already have submeters and you're billing tenants, you will need to bill your tenants as required under Senate Bill 7, meaning there are specific disclosures that are required, and there is specific information you must provide to your tenant if they ask you, such as where is the current submeter located, and how and when is the submeter read. You are allowed, finally, under Senate Bill 7, clarity in that you can charge tenants an administrative fee, meaning every time you bill the tenant, it's now clear in the law that you can bill them an administrative fee for doing and sending the bill. You can charge late fees if the tenant does not pay the bill. You can provide a 3-day notice if the tenant does not pay their bill. You can take a portion of the unpaid or all of the unpaid water bill out of a tenant's security deposit. The law does not speak to or address specifically or affect rental ratio utility billing systems, or as we call them, RUBS. It's not prohibited in the current statute. We've also included or have written a background paper on this topic. We have a year, of course, to get up to speed, meaning all of you who may already be billing tenants. So the background paper will be provided to you as well at the conclusion of this webinar. I'm going to ask Heidi to explain Senate Bill 2362 and remind you what the current statute is for those of you who are applying pesticides.
Sure. Last year, legislation was passed that requires owners who do their own pesticide application to provide a specific notice to their tenants. What SB 2362 does is expand that law to apply to common interest developments. Previously, there was an exception for condos where this law did not apply. It does now. So for those of you who do your own pesticide application without a licensed pest control operator, you are required to give a notice to affected tenants, and who those affected tenants are depend on where you're doing the pesticide application and also what type of pesticide is being used. We have a paper and a whole bunch of forms to help you comply with this law. Of course, CAA recommends that you do use a licensed pest control operator whenever possible.
This bill was a long time in coming. We already have some specific statutes that do provide some liability relief for those of you or anybody who may face a claim because your building is not accessible to somebody with a disability. This new law adds additional clarity by indicating that any specific technical violations that are presumed to not cause a person difficulty, discomfort, or embarrassment for the purpose of an award of a statutory damage in a construction-related accessibility claim. So somebody with a disability would not be able to file a claim or at least receive an award if it falls under the provisions, as we call the discomfort provisions. Now, this does, however, apply only in the cases where the defendant is a small business with 25 or fewer employees, and if the defendant or the building owner has corrected the violation within 15 days of receiving a notice. We've also updated our background paper for you on this. Because, of course, as you may remember, the current statute does provide a process for you to hire a technical expert to tell you what you may need to do to your building to make sure that it is accessible. So if you haven't already looked at that and you do have a property in which you especially have a management office, you want to take a look at that background paper.
The next new law for 2017 is Assembly Bill 2180 by Assemblymember Ting. This law was sponsored by the California Apartment Association, and it aims to expedite the housing construction permit approval process. Basically, what it would do is expedite certain timeframes from 180 days to 120 days, and other approval processes from 180 days to 90 days. I think the idea behind Assembly Bill 2180 is that it will ensure that badly needed housing projects will move through the building approval process faster.
In fact, the next couple of bills you're going to see were sponsored by CAA as a way to address the very challenging issue that we are all facing, and that's, of course, lack of housing. The next one there was also sponsored by CAA, AB 2584 by Mr. Daly. The law strengthens a current statute known as the Housing Accountability Act. It would expand, or it does expand, the list of those individuals and organizations that can help enforce the law. Specifically, it provides that a housing organization like CAA can file an action against a city or local agency if they do not approve a new development and fail to make specific findings when they deny that housing project. Unfortunately, we're seeing at the local level many housing projects, badly needed housing projects, being denied by local officials. This will give CAA the ability to challenge those denials so that we can see, we hope, more housing development at the local level. As you all may have heard and we'll talk about later, unfortunately, some of the ways in which local government is choosing to deal with the lack of housing production is to impose rent control. And the bills that we posed take that focus off of the rent control and point to the fact that we just don't have enough housing for those people who are in need. So thus the reason why CA introduced these bills. The next one there, also sponsored by CAA, is intended to ease again some of the barriers to the development of what we call second unit, or sometimes you hear of them referred to as granny units. It streamlines the statewide process and, of course, the local process. So anybody who applies for a second unit at their property, it must be ministerially approved, meaning it doesn't go through an extensive approval process at the city council or planning process. It must be approved within 120 days after receipt. The city or county cannot impose additional parking for that unit. Again, we call it an accessory unit here. If it is within 1/2 mile of public transit, if it's located within a historic district, or if the unit is part of an existing primary residence, or if there is a car share vehicle located within 1 block of the unit. No additional connection fees or local capacity charges for these units can be applied by the local government. We have experienced extensive connection fees, which has made it very difficult in these local jurisdictions for individuals wishing to build a second unit to even get it approved. So we were very pleased that the governor also signed AB 2299. And this is an interesting one that will affect those of you who may have what we call single-use bathroom facilities, perhaps in your leasing offices or other public area. They must be identified as all-gender facilities. We have a background paper on this that gives you samples of what your signs must look like. Under the law, a single-user public bathroom can't have signs that designate it only for men or only for women. They must be available to either or. Areas of the property that are open only to employees, residents, or their guests are not considered public areas and would not have to be changed or identified as all-gender bathrooms. So as I said earlier, the law will most likely affect those of you who have properties with bathrooms associated with your leasing office. If you make other areas of your property available to the public, such as a clubhouse, when I say public, I mean you rent it to outside individuals or companies, those single-use restrooms would also have to have a sign designating them as all-gender bathrooms. So that's a summary of the bills that we believe will have a direct effect on some of you coming up this year. As we indicated, we have updated our forms and we have background papers that we will also make available to you after this webinar is over. We want to spend a few moments to tell you about the 2016 election results, what the legislature will look like next year and beyond. And we want to tell you about some of the legislation we anticipate facing facing all of us in 2017. And then Heidi's going to spend a few moments in the end telling you about the forms that we've updated, because you will want to make sure that you are using the most current forms beginning in January. So I'm going to turn it over to Sean.
Thanks, Deborah. Well, obviously the 2016 elections were very interesting from a number of different perspectives, particularly from the federal level. Here at CAA, we are focused primarily on state-level races, state senate, state assembly, and we had a very aggressive political program in 2016, mainly thanks to all of our members and their generous contributions to our political action committees. We were able to spend over $3 million in a 2-year election cycle. That puts us as one of the top business political organizations in Sacramento. And what our goal has always been is to support candidates who support rental housing issues, whether it be Republicans or Democrats. Our main priority is to find people who understand the work that you do, the challenges that you face, and how to best improve California's climate as it relates to housing and rental property. So I would say in 2016, we had some positive aspects. We successfully helped elect pro-business, moderate Democrats. That's often the group here in the legislature we focus on the most, because Democrats are overwhelmingly in control. But then similarly, we also helped a number of Republican legislators who were running for re-election in difficult competitive races. We wanted to make sure they keep their seats and get re-elected. So just a breakdown in terms of the Senate and Assembly. I think the more problematic or concerning outcome of the election was that both in the Senate and the Assembly, the Democratic Party gained a 2/3 majority in both houses. They were a couple of seats away in the Senate. They won 2 seats. In the Assembly, they won 3 seats. So they will have a supermajority now. You know, they will continue to control the agenda in a significant way. But I think to help offset some of that, we saw a lot of moderate Democrats that we helped get elected that provide a good counterbalance to some of the more progressive members. So what does the legislature look like? In the Senate, there are 27 Democrats to 13 Republicans. You can see that it's pretty, it's pretty difficult from the perspective of Republicans. There's so few of them in a body of 40, so it's always, always a challenge. And in the Assembly, there are 55 Democrats to 25 Republicans. Again, overwhelmingly a majority of Democrats. So this is the environment in which we operate up here in Sacramento when it comes to legislation, when we're advocating on your behalf and trying to pass a bill or stop a bill. You know, we always start with these numbers in terms of collecting votes. So it keeps getting tougher every year, but we keep working and helping build relationships with members and educating them on what you all do in your business every day.
Thank you, Sean. We came up with a list of legislation that we anticipate for 2017, given what's going on in the local markets and given what we've heard and dealt with over the last couple of years. So on defense, and that's what we're focusing on here, what we anticipate, unfortunately, because of the rising rents in our local jurisdiction and because we saw 5 rent control measures here in Northern California, and we're hearing of those in Southern California as well, we do anticipate that there will be legislation that will attempt to amend Costa-Hawkins. Costa-Hawkins, for those of you who don't deal with that on a daily basis, is the state legislation that we passed in the late 1990s that says that if local governments pass rent control, it cannot be imposed on new construction, and it has to decontrol, if you will, any unit that has a vacancy so that the owner can bring it up to the current market rate. It protects and has protected owners in the most extreme cases in those jurisdictions that had historically had very challenging rent control measures. The second one there is the Ellis Act. Sean mentioned that earlier, and that is legislation we've dealt with for years. It's legislation that attempts to prohibit rental property owners from taking their units off of the market. While we see this predominantly in rent-controlled jurisdictions, it could happen in non-rent-controlled jurisdictions. Usually when housing is tight, meaning there's not enough housing and vacancy rates are challenging, and you see rising rental prices, you'll see local governments attempt to impose the Ellis Act. State law, just like it does for Costa-Hawkins, makes very specific standards about the Ellis Act, requires and allows rental property owners to go out of business, but it does require rental property owners to give specific notices. Legislators have wanted for years to change that and prohibit rental property owners from going out of business. I don't doubt we'll see another attempt to change that law here in Sacramento in 2017. Inclusionary zoning, again, we mentioned that earlier. We no doubt will see legislation that would attempt to require a very specific percentage of new housing to fall under either rent control or affordable housing requirements. Just like we dealt with this year, Section 8, we will probably see another ban on discrimination. Added eviction protections for tenants, we anticipate we'll see that as well because, again, of the rising rents at the local jurisdictions. And a new one, telecommunications, mandates so that providers can access your property so that tenants can use any provider that they so desire. As you can anticipate, this is a challenge for property owners who are concerned about the access, the changes to their building, either the wires running through their building, and of course, as we also often say, a kind of a spaghetti string of many types of different wires that are connected and disconnected. So we anticipate we'll see this because we're already seeing it raised at many of our local jurisdictions and at the federal level. We provided for you a couple of slides to tell you about what we dealt with in Northern California this year, specifically on rent control. There were 5 rent control measures on the November 2016 ballot. CAA led very aggressive campaigns to defeat each of them. We defeated 3, San Mateo, Burlingame, and Alameda. Unfortunately, however, voters did approve measures in Mountain View with Measure V and in Richmond with Measure L. In Mountain View, the ordinance does roll back rents to October 2015. It caps rent increases between 2% and 5% per year. Owners must show a very specific cause or list a very specific cause in order to terminate a tenancy. It creates a rental housing commission that will make the decisions about the right or wrong way in which rents are increased. And owners cannot raise rents until September 2017. We are going to have a more extensive webinar for those owners in Mountain View to provide a summary of this measure. And I anticipate we will be doing a lot more by way of challenging what these measures allow or are presenting for our rental property owners. And in Richmond with Measure L, the ordinance rolls back rent July 2015, limits increases to the rate of inflation, imposes strict eviction controls. Owners cannot raise rent less until September 2017, and also establishes a rent commission to oversee the rental housing industry in the city of Richmond. Here as well, we will also have a separate webinar for those owners in Richmond to provide information, more detailed information for those owners in Richmond. I'm now going to turn it over to Heidi and have her give you some highlights from those forms that you want to make sure that you have either downloaded for members. It is free of charge from the California Apartment Association.
For 2017, we have made more changes to our rental and lease agreement than I think in any of the prior 10 years. For this reason, in January, probably in the middle of the month, we're going to hold a webinar specifically about the rental agreement, what's in there, why it's in there, and what it means. So I'm just going to provide some highlights of the changes for you now. We've added a number of prohibitions. We've put in language prohibiting payments by third parties so that you're only getting the rent from people that are actually your tenants. We've added a prohibition on moving the appliances that you have provided to the tenant and on the tenant installing their own new giant appliances. This came up from a question on our landlord helpline, actually, about a tenant who had put in an additional refrigerator in the dining room because I guess the kitchen was too far away. Next, we have added a prohibition on all of the things that are now legal relating to marijuana, certainly use and cultivation, but also giving it away to your friends. We have added a prohibition on use of e-cigarettes and vaping to our smoking prohibition. We did make changes to the smoking policy addendum, so if you do want to allow use of e-cigarettes, for example, you are able to do that. We now also have a prohibition on storage outside the unit, and to go with that, we have a new storage addendum, which I'll talk about in a minute. We also clarified in the rental agreement some provisions relating to hoarding to give you a little bit more ammunition if that ends up being a problem on your property. Clarified rules regarding use of parking spaces for things other than parking a passenger vehicle. All those other uses are prohibited. We also clarified the renter's insurance provision to make it clear that it's really the liability insurance that this provision is about rather than coverage for the tenant's possessions. That was in response to a recent court case where the court had held that coverage for the tenant's personal property wasn't material and therefore the landlord could not require that. Liability coverage, of course, is different because that provides a significant benefit to the landlord. We also have some new provisions, the mandatory bed bug notice that I mentioned already. In our lease, you'll find a paragraph that the tenant has to initial saying that they received the separate bed bug notice. There's a provision that requires the tenant to cooperate with necessary repairs. This is a parallel provision to the right of entry when you go in to do those repairs, that the tenant not create problems. And then we also added a provision in response to member requests that the owner doesn't have liability for packages left for the resident. Of course, if you have a setup where you do accept packages on behalf of the resident, you could put that in a separate addendum, what your procedures are for that. We have a few new forms this year. First is the storage addendum, which I mentioned briefly. This form is set up so that you can either include a storage space in the rent the tenant is paying already, or you could have a separate rent amount for that unit. That's a new form for next year. We also have a long-term guest addendum. As our rental agreement is currently set up, you can set a time limit for guests. If your tenant has someone coming to stay for an extended period, for example, if the tenant has just had a baby and grandma wants to come and stay and help out for 3 months, this agreement would let you allow that, provide a way to do that, yet still have a fixed time period for that person to stay and eventually leave. That's a situation where you wouldn't necessarily want that guest to become a tenant with any rights. We also have the bed bug addendum, which I talked about already, and then we made revisions to the pesticide application by owner forms because those now apply to condominiums and other common interest developments. And it looks like we have a whole slew of questions.
Thank you, Heidi. And I want to thank all of you who are participating with us. I know we have a lot of questions, and I want to cover a few of these, and I know that Heidi is our expert on some of these. One of them has to do with the age of a building, back to the accessibility issue. The question is, what if my building's really old? Heidi, do they have to bring their building in compliance with the law and make sure that somebody can access their rental unit, even if they have a building that was built in 1927, for example?
Well, the ADA does apply to buildings that were constructed before it was passed. However, you don't have to comply perfectly with the same standards that would apply to new construction. Obviously, that's not going to work. For those public accommodations that predate the ADA, what you're required to do is comply with what's called a readily achievable standard. And that's going to depend on your resources and the conditions of your property. So what CAA recommends is that you work with an ADA consultant to develop a plan to remove barriers to the extent possible on your property over time. That's something that, should you ever run into a problem, is going to provide you with a good defense that you're making this good faith effort to comply. Obviously, for something like a 6-story building from 1920 that doesn't have an elevator and the manager's apartment and office are on the top floor, installing an elevator isn't going to be readily achievable, but perhaps having some type of intercom system for someone to talk to that manager would be. So it really depends on the conditions of your property. But if there is a public accommodation, which means an area that's not just for tenants and guests, then you do need to meet the readily achievable standard.
And Heidi, a property owner probably would be in good stead if they used a professional, especially if they have a larger building, to tell them if they're in compliance, as we have an allowance under current statute.
Yes, absolutely. If you do use one of the people that are certified by the Division of the State Architect, you can find those online. There's a link in our background paper, which we'll provide to you. If you use one of those people, they can come up with a plan for you. They can identify issues where you could possibly do better. And state law does provide some liability protections if you do go through that process.
Perfect. Now we have a couple of questions on the bedbug topic. Heidi is our compliance officer and is an expert. I don't know that you wanted to be the expert, but have become quite the expert on bed bugs. Now, the state law did not specifically address who pays, how they pay if a tenant caused the problem. And we do have a question, can we charge a resident if they have bed bugs?
Well, because the law doesn't say anything specific on that issue, it's really like any other habitability issue. If you can prove that it's the tenant's fault, then you can make the tenant pay. And if they don't pay voluntarily, you could take them to small claims court over that or anything else. Just like if the tenant broke a window in your lobby and you could prove the tenant did it, they would be responsible for those costs.
And I guess the caution here, because we've seen this quite extensively in our local jurisdictions, if you have a very large apartment complex, we do know bed bugs spread very quickly, and so sometimes it is difficult to prove where it came from and which unit it came from. So we would just caution that you use caution when trying to decide who caused it and where it was started. And if you have maintenance personnel going in and out of units that are not protecting them and their clothes, moving bed bugs from unit to unit it can be a big problem.
And of course, the most important thing here is to deal with the bed bugs first and then worry about making the tenants pay afterwards, because if they spread to other units, that's really going to be on you rather than on that tenant.
Yeah, and that's what we have found with some of our local housing providers, that when they made it very clear that the tenants were responsible for the payment of the bed bug eradication because of the infestation, tenants were hesitant to notify, maybe try to do it on their own, and the bed bug spread rapidly and made it a very challenging effort for the rental property owner to get rid of those bed bugs. So many of those policies have changed at the local level.
And that's why there's that anti-retaliation provision in the new state law. And in our bed bug addendum, we do have some specific tenant responsibilities. So we'll go through that in February when we have our bed bug webinar, which will have lots of nice pictures.
Those are fun pictures. We have a really good question. It's an overarching policy question about what programs or plans are supported by CAA increasing the supply of low-income housing. If this supply existed, there would not be as much push for rent control, would there? Very good question, and very good probably point that you're making with a question. We agree with you. If there was more housing production, we wouldn't see some of the local rent control provisions that we are seeing. CA, as we pointed out, did sponsor legislation this year to get at that issue. We held a housing summit this past October where we brought in experts from around the state, from the legislature, from our local universities, to talk about the problems and challenges that our local jurisdictions are facing with housing production, and the NIMBYs, or the not in my backyard push that we all face when housing is proposed at the local level. So CA will continue to sponsor and support legislation in 2017 to increase housing production. And we will look to the October seminar that we held. We had a lot of great ideas. We'll bring everybody back to the table again, and we hope that we can also provide some valuable legislation this year that the governor will sign and help. We have a question here about the water submeters. I've heard that because of how SB 7 is written, that any property that does not have a RUBS program in place by 1/1/18 will not be allowed to implement a RUBS program after that date. Is that correct? The answer is no, that is not correct. The actual provisions of SB 7 simply say that it does not promote and or eliminate or interfere at all, those aren't the exact words, but that is the intent of anybody's RUBS program. So you could continue to implement new RUBS programs and continue with your existing RUBS programs. Again, the actual background paper that we have links to the statute and does talk about that topic.
There's a question about medical marijuana patients and if their use of marijuana can be prohibited on the property. This is a slightly different question than recreational use of marijuana because it brings in fair housing issues and the question of whether a tenant's request to use medical marijuana to smoke it in a non-smoking building, if that's a reasonable accommodation. CAA's position and that of most attorneys who represent rental housing providers in California continues to be that owners can prohibit the use of marijuana on the property, period, whether it's medical or not, because it is still illegal under federal law. It's not a reasonable accommodation because of the potential risk that puts on the owner relating to federal enforcement and asset forfeiture. While enforcement of federal drug laws in this type of instance obviously hasn't been a priority under the Obama administration, it's unclear how things in that area are going to move forward next year. So at this time, our position continues to be that it's not a reasonable accommodation. Of course, if you want to allow it, you should talk to your attorney and develop some policies for your property on how you're going to go about doing that.
Thank you, Heidi. Back on the pesticide issue, the question is, does a pesticide notice have to be provided to all tenants or just the property owner or manager? Now, I'm guessing what we're talking about is the homeowner association provisions, because of course there's the two different statutes.
Right. So what needs to happen is the person who's applying the pesticides, say if it's the manager at a homeowners association or if it's the owner doing it to their own apartment building, they have to provide that notice to tenants. So if you have an owner of a condominium who's off site somewhere and they're just the owner, but it's the manager applying the pesticides, that owner doesn't have to get that notice. You might want to give it to them anyway so they know what's going on their property. But the purpose of the law is for the person residing in that unit, residing next door to that unit, to be getting that notice about pesticide application.
Thank you, Heidi. Somebody has a question about our bill 2299. That was the bill that dealt with the additional accessory unit. So what if we want to build an additional 25 units at an existing property? You know, our bill dealt, of course, only with the one additional unit at the property. It did not deal with adding additional units. You would more than likely have to go through the existing process that deals with your permitting at the local level. So that was beyond the scope of the bill that we sponsored and became law. There's a question here that says, we do not currently have signs on our single-use bathrooms with all gender signs. Would they be required? Heidi?
As long as that's not specifying who it's for, one gender or the other, that should be fine, as long as it just says restroom or something on it.
Exactly.
Yeah.
Yeah, in fact, I don't think the statute was very specific on the kinds of signs. It just cannot be.
Can't only be a dress.
Exactly, just a dress, exactly. It says here, would a gym bathroom be included in an all-gender rule? And again, I think that goes back to the issue of, is your gym available to the general public?
Right, because this law only applies to those areas that are open to the public, which it's unlikely that a gym that's for use by your tenants and their guests would be.
Correct. We have another question, again, back on the sub-meter bill. Does CA have a feel about how SB 7 would affect plumbing systems designed in multifamily buildings after January 2018? If a building is designed with vertical risers, how can it be metered if the state doesn't have an approved point of use meter? Currently, the only sub-meters approved are a point of entry type that are placed on horizontal supply lines going into an apartment. That's a very good question. In fact, the bill does specifically indicate that there may be exemptions for high-rise buildings, for example. It sends to the Building Commission and to the Department of Housing that very issue to make sure that we don't mandate it when it's and could be impossible. So there is provisions within the statute that speak to that, and there will be additional work on that very topic. Back on the issue of all-gender bathrooms, where can we find examples of the all-gender bathroom signs? We have pictures of those all-gender signs in the background paper that we're going to send to you this afternoon. A question here on the bed bug law. Do you think there's going to be an effort to reverse that bed bug law? No, I don't believe that there will be. We have a lot of jurisdictions that already have bed bug laws. We have been concerned that we would have laws that were much more stringent than what we had. I don't remember, did we end up with some language in there that prohibits new bed bug ordinances?
No, we didn't. Originally, the way that the bed bug legislation started out, it had very extensive, detailed duties for both landlords and tenants along the lines of, after 3 days you do this, 5 days later you have to do this, within 10 days you have to do that. That was all taken out, and as part of taking out all of that really prescriptive stuff, the preemption of local ordinances was taken out. So, for example, San Francisco's ordinance that currently has regulations that are probably 40 pages long, that continues to stand.
Thank you. Here's a specific question again back on the all gender bathrooms. Can we choose to change one of the bathrooms accordingly and retain the second bathroom for a private use for our employees, for example?
Yeah, absolutely. The law only applies to those bathrooms that you offer to the public. If you have a bathroom that the public is not allowed to use, that is only for employees. That is not a problem at all. We had a question about also, are the revised forms available now? Yes, they are. As of today, they go live on our website. So if you checked early this morning, perhaps not, but they should be up there now. Another question about forms: is the revised lease agreement editable? No, it is not. Our forms have to be used intact as they appear. You can't add your own provisions or take provisions out of our forms and put them into your own lease. We do offer a fill-in form service where you can have it automatically populate with your information regarding your property. And we also offer the forms to input into your property management software, but none of those options allow for the actual text of the form to be changed.
And Tim asked, do we have any new eviction laws? We don't have any at the state level. Just the ones that I spoke to you about at the local level in those rent control jurisdictions. Those are the just cause, meaning you can't just give a 30 or 60-day notice. You'll have to give very specific reasons why you're terminating those tenancies in Richmond and Mountain View. There's quite a few questions I think that we want to remind you about. This recorded webinar will be available to you at the conclusion. The slides will also be available, as well links to all of the background papers that we are referencing. There are questions about can a tenant not deny entry for needed repairs even if they are not home. Certainly we didn't talk about that topic today, but there are very specific reasons listed in a notice of entry under the statute and of course in our form. Some tenants will deny you entry. You would need to give, depending upon what lease you use, if you use our lease, you'd want to give a 3-day notice to comply so that you can enter the home. We always caution you, however, if a tenant says no, do not simply enter the unit without very specific notices.
Yeah, you do in most instances obviously have to give a written 24-hour notice before entry. If the tenant refuses, our recommendation is that you serve a 3-day notice. While you do have the right to enter in those circumstances, under state law, the best approach is to give that 3-day notice to require the tenant to comply with the law and the lease and to give them a chance to comply.
Under the bed bug provision, the question is, does this apply to month-to-month contracts? And the easy answer is yes.
Yes, absolutely. It applies to any lease or rental agreement of whatever duration. Starting in July, it does have to include that bed bug notice. we put it into our forms effective January 1st just to increase the chances of everyone having it in there in time.
This is sort of on the topic of the accessibility. It may also be a fair housing issue. The question is, we have a building and an elderly tenants who have asked for an elevator lift to be installed. Does the owner, says, are they liable, or I think the question is, do they have to install it?
Fair housing laws require you to do two things with respect to disabled tenants. One is to provide a reasonable accommodation, which we just talked about. It's a change in your policy, for example, smoking, where you're considering whether or not to allow smoking of medical marijuana. The other part of that is a reasonable accommodation, which is actually a physical change to the property, and that's what this example is here with the elevator lift. If the tenant is disabled and they do need that modification to use the property as any other tenant, they are entitled to that change, but it's not at the owner's cost. That's something that the tenant would have to pay for themselves. More common examples are grab bars in the shower, widening a doorway, installing lower countertops that can be used by someone in a wheelchair. All of those things generally are reasonable modifications if the tenant needs them, but the tenant is required to pay. We do have a paper that addresses that in more detail that we can link in the materials we provide after the webinar.
Another question on the second unit, does the law supersede local ordinances, for example, in Oakland? The answer is the local cities and counties must comply with the state law. So even if they had their own local ordinances, they have to be consistent with the state law that we passed. So in other words, if you want to build a second unit, they can't charge you the extra fees, and they can't require the additional parking standards if the unit is located close to public transportation.
I see a couple more questions on here about the ADA and how it applies to smaller properties. The thing to remember with the ADA and its accessibility requirements is that it applies to public accommodations. Generally, if you have a duplex, if you have a single family home, or even a property with 4 or 5 units, there isn't going to be any part of that property that's a public accommodation. There's no area that is available to people other than tenants and guests. There's no leasing office, there's no parking for the leasing office. So the ADA isn't an issue for those properties. Fair housing law, reasonable accommodations, reasonable modifications, that does still apply.
Heidi, here's a very specific question for you, our expert. Does the bed bug law provide that a professional exterminator supply a report to the owner regarding the probable source of the bed bugs?
This question is from Alan Simpson. Hi, Alan. The bed bug law does not actually regulate the pest control industry. We did talk about putting some provisions telling them how to do their job in there. That did not end up in the legislation. We are going to be working with the Structural Pest Control Board, though, to put some bed bug education requirements into their regulations for the pest control industry, including that they follow the National Pest Management Association's guidelines.
And on that same topic, Sarah asks, can you deny an applicant if it's known that they had bed bugs at their last residence? That might go to the retaliation issue. And of course, the question, I think, begs more of the issue of proof. And there are requirements, I think, in our forms about the tenant signing saying they their personal property does not.
That they're not moving any bed bugs in, essentially. You know, and I would question whether that would be a good policy anyway, because the people that I know that have had bed bugs in the past, they're much less likely to have bed bugs in the future than those who are not aware of the issue. So as long as the problem was addressed for that tenant and they're not bringing them onto the property, To me, that doesn't really seem like a particularly good ground for disqualifying a tenant.
Here's a unique one that we can answer for you. What's the best way to respond when an applicant asks if he or she can use their second bedroom as an Airbnb? Our lease actually deals
Our
with
lease
that.
says no.
Our
That's
lease,
the best response.
that's the best response. CAA did sponsor and successfully move to the governor legislation that requires all of these types of entities like the Airbnb services to provide a notice on their websites to warn tenants that it's more than likely a violation of your lease if you attempt to use your unit or the second bedroom as an Airbnb unit. And within our lease, of course, we have that prohibition. We added that because many judges were making or they were slapping the tenant's wrist by saying, well, the tenant didn't know or didn't understand. There will be, we hope, no reason now for a tenant to say they didn't know, because it will be on all of those sites that it does violate their lease, and we hope that it'll be an additional avenue for you to move forward with a termination of tenancy if you so need to, especially if you have complaining tenants next door, which is often the case. We have some more pest control questions. If this is done by a professional, does a notice application need to be done for the exterior?
This law that we were talking about today doesn't apply to the notice from the pest control operators. The only law that's out there about notice from pest control operators in the landlord-tenant context is if you have a contract for periodic pest control, if they're coming around every month to do something, the pest control company is required to provide that notice to the owner and to the tenants. And that doesn't distinguish between interior and exterior. There's another question here about this law. I just want to clarify, if the pest control operator is doing the pesticide application, it's the pest control operator that has to provide the notice. Unless you have a contract for them to come in every month, in which case you need to attach it to new tenants' rental agreements. Unless that's the situation, if it's a one-time thing, it's the pest control operator that's going to provide the notice. You are only required to provide the notice if you are going in there spraying and applying the pesticide yourself. We had a question about the definition of a pesticide and whether a mousetrap counts. A mousetrap does not count. There is a definition in our paper and in the instruction sheets for those forms. It is pretty much just things that you would think of as pesticides. It doesn't include things like bleach, for example, even though technically that is also a pesticide.
There is a question about the retaliation provisions. There's a very specific definition of retaliation. I think it's defined by days is one way to define it. I think it's 180 days under the current retaliation law. So if you do anything such as increase the rent, serve a notice, or do various things that could be tied back to the bed bug issue, and that could be defined as retaliation, it's usually within that 180-day timeline.
But it's just a presumption. So, for example, if the tenant doesn't pay their rent and you serve them a notice for non-payment of rent, it would be pretty easy to show that that's actually why you served that notice, not because they reported a bed bug infestation to you.
Yeah, that's a good clarification. Heidi, can you reiterate the hoarding info that's in our new forms?
Sure. There's a section in the rental agreement that deals with tenant responsibilities for maintenance of the unit. And the language that we've put in there that addresses hoarding has to do with not blocking access within the unit in hallways, not blocking access to windows, keeping all of the appliances in ways that they can still be used, keeping all the fixtures in ways that they can still be used. For example, not filling your bathtub up with turtles so that you can't take a bath. And then, of course, fire safety issues. So there's a lot of specific language in there now about how you have to keep the unit that can be used to address hoarding problems.
Is it legal to not renew a lease without a reason, or would that fall under the just cause eviction? Certainly state law has nothing to do with the just cause. I mean, you could not renew a lease. In fact, you need no reason at all. The lease just expires upon the final lease termination. But the just cause in the local jurisdictions is different.
Yes. Under the local laws that require a just cause for eviction, these apply to termination of month-to-month tenancies or to non-renewal of a lease. So in a rent control community with just cause, for example, in San Francisco, the tenant essentially has a lifetime lease as long as they don't violate any of those just causes. So as long as they're not doing anything illegal, narrowly defined, and as long as they're paying rent and continue to follow the rules of the tenancy, they pretty much get to stay there, and it doesn't matter whether you renew the lease or not.
Yeah, that's always the very big challenges with just cause eviction that we have opposed in the past. We have a question about, back on the submeter, does the law apply to commercial properties? And no, it does not. It does not require installation in units within property that are used only for commercial purposes. If there are, of course, mixed use, the units that are specific for residential would require a submeter. There are some questions here about Mountain View and also about Richmond. We're going to skip those, and we will provide copies of our background papers on those two local laws, and then of course you will want to watch for the webinars that we're going to hold on those topics coming up soon. With that, and of course we're well past our hour, we're going to conclude our webinar for today. We will again provide a copy of this webinar, the recorded version, as well as the PowerPoint slides and the background materials. I'm going to turn it back over to Dana David to make a few remarks in closing.
Thank you, Deborah, and thank you, Sean and Heidi, for all the information you provided today. I anticipate that we didn't get to everyone's questions, but please don't worry. The staff will provide additional answers when they send the PowerPoint out to each of us today or within the week. We will also include links to the compliance papers that were referenced today as well. I thank you for all for your participation, and I hope that you have a wonderful holiday season. I, for one, am looking forward to spending time with friends and family and need to go remove the turtles from my bathtub. So I'll be doing that right away, Heidi. Have a great afternoon, everyone.
Thank you, and thank you all for participating.